It is registered as a petition. And it arises from the state of UP.
Fine.
The prayers that is
Filed in Article 32.
we are not every prayer in that structure I mentioned in paragraph 2 of my application. The first prayer that's the topic is but the prayer is to cancel all the appointments in the various states. Basis of that trend. Considering that what should be stand of the state government is required to be.
Your reply is not there.
Your reply to copy which I have been supplied. There is no prayer which is reproduced.
The state's reply is there or not there?
They are required. These are appointed contest
Petition.
Return file. Oh, this Gundu Singh, where is this petition? First, what is challenge there?
But none of us is aware of this, and there is something from the state of UP Maharashtra filed in the Article 32. Yes. Previously, they took shelter of Arnab Ghosh, filed from state of West Bengal.
Let us see what they are. What is this Gundu Singh petition?
All humbleness on my command. Today it is Gundu Singh, tomorrow it may be Rameshwar Singh. Previously it was Arnab. They will try to deference that it should not be hard at any cost. And this is what it has.
That trend should not make this.
And you should hear Gundu Singh's prayer. If you move an application,
Please find a transfer petition. That should not be from where all this is coming from. Affidavit. Affidavit. Please hold your office.
Let us see.
Gundu Singh had filed Arnab prayers for business.
I've supplied.
Gundu Singh's copy.
I've supplied the IA filed by Gundu Singh. What is Gundu Singh about? You are not aware of it. You are saying you are not aware of some Supreme Court and applications. We are showing it to the court. We give it to you. You are disputing that. I'm disputing.
No, please dissuade yourself from making any personal remarks.
Something which is completely irrelevant.
No, my request is to both the parties. Some ground. This petition, yeah. Here you go. Somebody need to blow a hole. Do that. Nothing else, you know. Recording. It is complete करने के लिए. You have filed it for transfer on what date? 25/1. A2. How many B.Ed appointees are there who are adversed by this judgment of Sharma? How many B.Ed appointees are there who are adversely affected by the judgment of the Apex Court?
My lords, the statement made before the Supreme Court, if I remember,
Large number.
a very large number. On the last date, it was said before the Supreme Court when Arnab Ghosh matter had come up. And at that time, be that as it may, the Supreme Court clearly said that where for primary school teachers, the qualification is only D.El.Ed. There cannot be a B.Ed appointment for the post of primary school teachers. And the court at the time of dismissing Arnab Ghosh also observed that while B.Ed teachers can be appointed for the secondary education as well as for colleges and other levels, the D.El.Ed qualification is limited only for the school and none other. Now, my lords, in that context, if my lords will look at two applications that were filed before the Supreme Court, the prayer was identical as it's today. If I can just show you, to allow B.Ed people who had participated in exams, etc., prior to Divesh Sharma judgment. And in both those applications, the Supreme Court dismissed the applications or dismissed the writ petitions as the case was. I can just show my lords 2 pages of that.
Yes.
Yes, my lords, yesterday we tried to give you that compilation of those various cases. And in that compilation, if just coming to this aspect itself, that this was the relief before the Supreme Court post Divesh Sharma, if my lords may first take page number 16 of that compilation. This, my lords, is the compilation, and in that at page 16 is that application for modification, clarification. We have put only the prayer portion, but filed in the case of Arnab Ghosh. At page 17, my lords will find the prayer that was made before the Supreme Court. Do my lords have it?
Violation of judgments.
My lords, it's a compilation of orders passed by the Supreme Court from time to time, post Arnab Sharma, post Divesh.
Lord, the entire petition may be seen, my lords, because the major difference will be they are not
Miss,
appointed,
I am sure,
unlike in this case.
My lords, I
They
thought
were
we were
still
on a
not
VC
appointed.
and I thought we were on a VC, and I also
Yeah.
thought that we do not interject and we have always an opportunity, which I'm sure my lords will hear the other side. Now, please see this here.
Page 17.
Yes, my lords, the prayer in Arnab Ghosh is at page 17.
Yes.
To modify, clarify that any recruitment prior to judgment dated 11/8/2023 passed by this honorable court in civil appeal, that is Divesh, shall not be interrupted. And
I don't think we are on the same page.
my lords, do you have a compilation in which it is the head note is this?
It contains main prayer.
Yes, it contains only the prayer, because my lords, it would have become.
Is it the printed page 8 or handwritten page 17?
My lords, does it read as a counsel for the applicant Neha Rathi, and it has a prayer, and the previous page of that is the covering page of application for modification, clarification.
Yes.
My lords have that. I hope we have the same page, my lords.
Yes.
So if my lords may just read that prayer with me, and I will take you to the order immediately.
Yes.
So, my lords, the prayer is to modify, clarify that any recruitment process that has commenced prior to judgment dated 11/8/2023, passed by this honorable court in civil appeal so and so, that is the Divesh Sharma, shall not be interrupted, and appointment shall continue to be made as per recruitment notifications for recruitment to the post of primary teachers issued prior to judgment dated 11/8/2023. Now, this application with this prayer, that if you have commenced and you're carrying on the appointments, please do not do that because they are prior to the judgment in Devesh Sharma. That's effectively the prayer. This was first originally rejected by the registrar, saying that it is in the nature of review. That is the next order. We are not concerned with that. There was an application then filed before the Honorable Court for setting aside the registrar's order, and my lords will find the order of the Honorable Supreme Court dated 11th of January 2024, dismissing this particular application at page 2930. Arnab Ghosh versus Union of India.
But the very same way, you have to Devesh Sharma. This is another problem from India.
Do my lords have that page of the Supreme Court dismissing that application?
Yes, yes.
Now, my lords, I want to show just one more, which is also very important. Please come immediately thereafter. There was a writ petition under Article 32 filed before the Supreme Court, which is immediately the next page after this order, page number 31.
Yes.
That is called that B.Ed Chhatra Welfare Association versus Union of India. Would my lords just take a look at the prayers made in this writ petition at page number 32? Issue a writ order or direction directing respondents to complete the recruitment process for the post of primary elementary teacher commenced on the basis of NCTE notification dated so-and-so prior to judgment dated 11/8/23 passed in Devesh Sharma. Then issue writ order directing respondent to consider B.Ed candidates as eligible and have completed B.Ed before the judgment of 11/8/2023 and who undertake to complete 6-month bridge course in elementary education. My lords, this matter came up on 22nd January. That is just a couple of days back. And the court dismissed this particular petition. It was withdrawn. When at the time when it was being withdrawn, we also pointed out to the court that the advocate filing this petition is the same advocate who had appeared in Arnab Goswami and had suppressed all material facts. The court did not allow them to withdraw that petition. On the contrary, dismissed it. My lords, they dismissed it as withdrawn, but for the purpose of appointment to the post in primary school teachers. My lords, it's a matter of eligibility today. It's a matter of qualification. It's a matter of a policy of the government, which the Supreme Court has today upheld and quashed the notification by which B.Ed was sought to be included as a qualification for purposes of appointment to the post of primary school teachers. Now, my lords, having said that, I wish to just impress, and of course, my learned colleague, Mr. Vigyan Shah, is there, and he will take you through the judgment passed by the Patna High Court, in which the facts are very, very similar. He has a copy. It will be easier for him being physically present to take you on to that. But I wish to press before you one simple principle. Today, a large number of these appointments have happened, which is after the judgment had been delivered by Rajasthan High Court. The principle here is a notification issued under a central legislation. The central legislation, the NCTE Act, which sets out eligibility criteria and qualifications for appointment of teachers across the country. This is not a legislation, or this is not something which is within the state's domain. It is done under a central legislation. It applies across board, across the country. Once the High Court of Rajasthan quashed that particular notification, my lords, the notification goes out completely. Any made apropos to that particular notification is bad for that reason completely, because then they are not qualified. The Supreme Court did not stay Rajasthan High Court judgment. The Supreme Court merely said subject to the outcome. Now, my lords, today Supreme Court has upheld the quashing by Rajasthan High Court of this particular notification. So to say that even if some appointments have been made, and particularly having been made after the judgment of Rajasthan High Court has come, which has already quashed this particular notification act, the act under which the notification is being issued, applicable across, has been already quashed. So there cannot be appointments to be made. Today, reliance can't be placed on saying that, well, I have been appointed, but if the appointment has come on a basis of a qualification, first of all, which is not permissible, which is not eligible for the post, and number two, in any case, after the same has been quashed. My lords, I would respectfully submit that these cases are clearly cases today completely Divesh Sharma holds the field. This one or the other ground that has been taken to defer these proceedings by saying that, well, there was first Arnab Ghosh, now some Guddu Singh. Now, Guddu Singh judgment comes out of, if I remember correctly, because I know there's something in Supreme Court, it comes from UP. It relies on a principle of that Maurya, the other judgment, number one. And number two, my lords, this was regarding the cut-off marks. This had nothing to do with this. Therefore, every time when the matter is taken up for hearing, there is one means or the other to deflect that. My lords, I would most respectfully submit that today in
Small
can my
submission.
one minute, Miss Mona, one minute, Miss Mona. I think my colleague Vigyan has that judgment from that Patna High Court. We want to place that. My lords, I'm doing it. He has that physical copy.
All right,
Please hear that one.
Just a minute, let us hear Mr. Rupra. Yes.
Lord, my humble request is that my
You
Lord,
are appearing for whom?
I am appearing for those B.Ed. candidates, Lord, who are already appointed, Lord, in the month of March 2023. So, Lord,
No, and I fail to understand why is there so much of opposition from the state to hear this matter. Because there is nothing pending in the Supreme Court. The Supreme Court has decided the matter. The review has also been dismissed. Don't you think the review has also been dismissed?
My lords, the review has been dismissed.
So that review order, are you disputing that rejection of review?
You place that on record in the compilation, the order. The order has been placed on record.
My Lord, before going into the case, my Lord,
No, the impression that we are getting from the state is that they don't want to argue.
No. That is not.
We can't compel anyone to argue. Unless there is consensus to argue, we can't hear it.
That is not.
Please be very clear on that point.
The state is not saying that we have tried a TP. What the simple reason? My learned friend is aware of the detailed order. But if I may submit, subject to what my learned friend is going to clarify, the issues, 3 writ petitions. All that order that has been read, Arnab Ghosh and all of September 23, clarifications being filed and disposed of petitions. Supreme Court says, sorry, no, we're not entertaining all this. It's disposed of and disposed of. Fresh writ petitions are I have this order from 5th of January 24.
Fresh writ petitions filed by B.Ed. appointees.
At the Honorable Supreme Court.
So please save us from being.
So, my lords.
That is the request there.
That was discussed.
My lords. My lords, may I just point out how my learned friend is incorrect? The last 2 pages that I just showed to you, page number 32, 33 and 34 are fresh writ petitions filed on 6th of January. What is, I think other side must look at this.
Let my learned friend file a reply to the transfer.
No, there's no file a reply to transfer.
We can't compel any party who does not wish to argue to argue. That's a
That
the learned senior counsel on virtual law from Delhi. He is representing K.C. Nandan.
Yes,
My lord, there is nothing in K.C. Nandan. My lord is not sitting here in a PIL. There are no PILs, Lord, in service matter. So at least Lord K.C. Nandan's counsel should please sit.
Sorry, we are representing in both the matters. That may not be a correct statement. Mr. Arora is appearing in both the matters. It's not just K.C. Nandan. Please see the compilation, sir.
Things I want to say. Firstly, Lord K.C. Nandan's advocate, Lord, they must sit, my lord. There's nothing there, they have no stake at all. Second submission, my lord, is I was making at the outset, Lord, that I have made an application to be arrayed as an intervener in the case of K.C. Nandan, which has been allowed by my lord. But Lord, because K.C. Nandan appears to have become infructuous, I have made an application in the case of Vipin Kumar Dwivedi also to be arrayed as a respondent. That IA, my lord, of 17229 may kindly be allowed today.
So why has it become infructuous?
But because all the.
Maloj, who is he to say that it has become infructuous? I am the petitioner. We are the petitioners. Who is he to say that it has become infructuous? We are pressing for the petition, Maloj.
Court is questioning him on your behalf.
I'm so grateful, Maloj.
Matlab, yeah, we will boil all the things. Not will boil down to only one case, that is Vipin Kumar Devi.
Where is Vipin Kumar?
Vipin Kumar Devi is before my lord. We will argue Vipin Kumar Devi. He's my learned friend.
Defense counsel arguing by.
Please have a look. The relief clause of the case.
My lords, can I say that let the petitioners
Nandan
address
and
their
Rohit.
matter?
And Rohit,
Yes.
as regards both, it is infructuous.
That both of them have been appointed. I have decided to those orders. And please see their relief clause. And I will cite law before the Lordship. Supreme Court says High Court should not enter into these academic questions because these have become academic. Please see the relief. Whether they because the relief which ultimately they had claimed, they have already got that relief. Now, Manoj, kindly refer to clause 7, paragraph 7.
So petitioners are every time they start petitioners argument.
Must of all the counsel in Kesari Nandan, please don't say that anything. Kesari Nandan's case, please be decided first. It is an infructuous petition. Please have a look on paragraph 7 of the relief. Manoj, I'll just read relief clause. Kesari Nandan.
Last time, if I rightly remember, there was some submission made by the counsel for petition.
Not
That
maybe.
all these appointments are subject to the final
Yes, but
There is
I-
an order passed by my lords to that effect.
Permit me to clarify
Order passed by
that.
my lords to that effect.
Kindly permit me to make one submission.
If the petition.
Yes, Lord. I am for the B.Ed candidates. Your lordships have included me in Miss Meenakshi Arora's matter, where yesterday's submission was made that it is not infructuous because it is subject to the outcome is what the submission was. I'll make it clear, Lord. The writ petition challenges the B.Ed candidates from appearing and getting into the job, and therefore whoever B.Ed is being appointed will be subject to the outcome of the writ petition, Lord. There is no challenge to the appointment of a D.El.Ed candidate from being appointed. So what is being sought to be submitted here is that D.El.Ed candidate who has submitted to the appointment and joined, is that as if it is his joining as a D.El.Ed teacher is subject to the outcome, Lord.
That is an interpretation being given by Ms. Mona. Please see the prayers. We read the prayers for my lord's convenience last time. Please see the prayers. And it is not just Kesari Nandan that we are appearing in. We are also appearing in Vipin. We are appearing in both the matters.
My friend may allow me to complete the sentence, Lord. The writ petitioners are challenging not the challenge is to B.Ed. This is not a public interest litigation. They cannot pursue with the writ petitions. So therefore, there are other writ petitions which your lordships are anyway going to consider. This matter
clause 7.1 may kindly see. The release has already been granted. Manoj, may please see 7.1. It reads, Manoj, that the Honorable Court may kindly be pleased to impugn the notification dated 28/6/2018 and 30th/5/2018 issued by NCTE making amendments under notification dated 23/8/2018 issued by MHRD, Department of School Education, Government of India, whereby candidates possessing qualification of B.Ed have been made.
That Supreme Court has watched.
Now kindly come to the 7.2. The Honorable Court may kindly be pleased to issue an appropriate writ order direction not to treat the B.Ed candidates as eligible for the post of primary level teacher. This relief has already been granted by the Supreme Court.
What is granted is to continue fresh appointments. Supreme Court has not de-seated anybody. Supreme Court has only stopped any fresh appointments. And
No, I'm sorry, that's a wrong statement to make. That's a very wrong statement to make.
appearing in
That's a
those
very wrong
matters.
statement to make because we have produced those writ petitions.
The state government is not ready to argue.
Because they don't want to argue because they want to protect a specific. They are not wanting to argue for reasons best known to them. Manoj.
On that, by recording that statement.
Kindly see every time the state and every opposite council wants adjournment on one ground or another. This adjournment, my lords, is actually in their interest. They want these persons to be continued in violation of Article 21A. Any single day adjournment, my lords, would be at the cost of the children who are being taught now by the different teachers. Supreme Court, why they want to be Policy Article 21A.
Lord, as
They want to be made party with adjournments day after day on one count or another. Why not make NDC?
Supreme Court did not
Today,
take
it's
an appointment.
a matter for petitioners' arguments.
as far as we are concerned, my lord,
We have transfer file, he
the
can
judgment
take-
is clearly distinguishable on facts, my lord, and also we are very well protected.
No,
As
even
far as we are
otherwise,
concerned-
even otherwise, it will take time to be heard.
Yes.
Plus, it won't take time. My lords may just give us 5 minutes and we'll be done. Just 5 minutes.
Within 10 minutes.
5 minutes to show that nothing remains now. Just 5 minutes.
I'll not make any submission.
There's so much of opposition, even on hearing. Imagine what.
Because for obvious reasons, because they are placed. For obvious reasons.
Let him prove this. They will energy for the transfer.
Why should I say my energy? Transfer petition is actually miscarriage of justice where you have moved an application.
Kindly tell that to the Supreme Court.
Kindly tell that to Congress. Good thing comes from state of UP. There was no order. It's a writ petition filed under Article 32.
Because I am appearing in that writ petition, Guddu Singh, there is absolutely no connection. I am appearing in that matter. For some of the D.El.Ed candidates, there is no connection of issue. And my lord would recall that every time there is a new ground coming for adjournment. Why? Because these B.Ed candidates are serving.
Said that Arnab Ghosh if not decided, your lordship will deal it on merits. Arnab Ghosh was dismissed. If they were heard, Arnab Ghosh was dismissed. The lodgement order says that the consequences were to follow. No person who was appointed cannot be saved. Then the man of challenge that in Arnab Ghosh.
Incorrect statement.
Absolutely incorrect. Why can't you counter it on respondent being said that? It is clear that both applications intend to seek for recall of the review of the order passed by this honorable court in the guise of filing the present instance applications. The prayer made in these applications itself would make it clear that applicants intend to seek for re-hearing of the matter on merits after reviewing the order dated 11/2023, which is confirmed under law.
Read it petition.
But as far as we are concerned, my lord,
Very honorable.
All right, please start your argument.
Very well, my lord. So grateful.
We'll deal with the objection. We'll deal with the objection. We will deal with the objection. We will record that you are not cooperating. Yes, please start argument. Please start.
I'm refraining from this argument.
Manoj, just give me 1 minute. Manoj, give
Your lordship, the kind of government is 18.
before he starts his argument.
I started my argument.
Let him start it. Yeah.
I started my arguments. I am on page 18. As per your
We will call for your application, whichever is filed is not here with us. No, it's not uploaded. It's not on record. No, we will not see that. We will see the one which is filed. We'll call it whenever it comes, we will see. And then at least start arguing.
Please see page 16 first, the application that was filed by Arnab Ghosh. Please see 16 for a minute, and then we can come to 18.
If you can please wait for a minute. This is page 18 of the compilation. You are having. It's Devesh Sharma versus Union of India.
Sir, 1 minute. I'm making a request to the honorable court. To the honorable advocate general also, if the arguments are passed, you also.
Ask him to join in whenever but we can't.
Then I will take it up in the next week.
No, I'm sorry. I'm sorry. We reject that prayer. If you want, we can put it down and write. Please start.
Time to come to the compilation.
Please start your argument, Mr.
I started my argument. Kindly come to page 18, tab number 3. Now, Mr. Gadial, would you please allow me to make submission? Being a senior counsel, I hope and I request we have to learn from you.
Mr. Counsel, please leave that to the court. Handle Mr. Gadial.
There is no objection in his argument. I'm only saying that the Kesri Nandan case can be decided first because this has been rendered in first. Let him argue the other matter. I have no objection. No, but this Kesri Nandan case was.
Which case are you arguing?
I'm arguing in Vipin Kumar Devi.
He will argue Kumar.
Where is that? That is WP.
Well, that is second case. That is the next case. First case is Kesri Nandan. And I would like to place some law for the law as well as Nandan is concerned.
But I will not take it also to the files because there is a compilation.
28.1. 28.1.
Yes, this is 38.1.
No, that is Sakshi Trader.
No.
32. Sorry.
Please list Vipin Kumar is 32.1, writ petition 595 of 23.
595. Vipin Kumar Devi. Somewhere I'll just take your losses through this compilation. I'll not take your bother your losses with the files. I'll just be referring to the compilation.
Yeah. 32.1 is weapon command.
Yes. Now, Madam Secretary, Lordship has this compilation which Madam Meenakshi Arora was referring to, because not to bother with the with different compilation, please come to this. And let me take your Lordship to the lodgement order at page 18.
Can we show 17 first, if you don't mind? 17 is the prayer. The prayer would be important. Please show the prayer. At 17, what was the prayer in Arnab Ghosh?
17.
Which compilation are
This
you
is this
talking about?
No, this compilation which Madam Meenakshi Arora was referring.
Yeah.
It's just a compilation of orders, Malos, that has been filed for convenience. Orders and prayers. Nothing, no reading has been placed.
Yes, yes.
Now,
It
Lordship,
is-
Yes. Yes, please.
please come to the prayer at page 17. This was the prayer,
17.
page 17, running page 17. This prayer number 8.
in Arnab Ghosh.
Modify or clarify that any recruitment process that has commenced prior to the judgment dated 2023 passed by the Honorable Court in Civil Appeal number 5068 of 2023 shall not interrupt it. The appointment shall continue to be made as per recruitment notifications for recruitment to the post of primary tutors issued prior to the judgment dated 11/2023. So by this prayer, Maros, it is very clear that all those processes which have initiated the appointments being made should continue, and the judgment in itself should have a prospective overruling. The impact is prospective overruling. Now, Maharaj, what does the
Comment is
government
not concluded, ma'am. That's like 90.
comments concluded whatever
No,
it is supposed to
comments.
do? Now, please don't disturb in between. I'm making my submission. You may counter it. Now, Maharaj, can you come to the next page? The third paragraph. The judgment dated 25/11/2021 passed by the division bench of the Honorable Rajasthan High Court was challenged.
Where are you reading?
This is page
Page
18.
18.
Yes.
This is the order dismissing this application.
The judgment dated 25/11/2021 passed by the division bench of the Honorable Rajasthan High Court was challenged with the Honorable Court in Civil Appeal number 5068 of the 2023 and connected appeals. Apart from the said appeals, petitions filed under Article 32 of the Constitution of India, even with the same issue, were also tagged with the appeals. The NCT notification and issue notification dated 28/6/2018 exercising powers under Section 23(1) of the Right to Education Act 2009, making B.Ed degree holders eligible for appointment to the post of primary school teacher class 1 to 5. When the advertisement was issued on 11/1/2021 by the Board of Secondary Education State of Rajasthan, it excluded B.Ed degree holders from the list of eligible candidates, which came to be challenged before the Honorable Rajasthan High Court. The notification dated 28/6/2018 issued by the National Council for Teacher Education came to be quashed by the Honorable Rajasthan High Court, which held B.Ed degree holders to be unqualified for the post of primary school teacher. Thus, the issue that arose before this Honorable Court was whether National Council for Teacher Education was right in including B.Ed degree qualification as an essential qualification for appointment to the post of primary school teacher level 1. After detailed consideration of rival contentions, this Honorable Court was pleased to dismiss the appeals and confirm the judgment passed by Honorable Rajasthan High Court dated 25/11/2021. It is specifically observed that the Honorable Rajasthan High Court has followed the settled legal position and no interference is called for. The said civil appeals have been dismissed in terms of reportable judgment. This Honorable Court, while disposing of the said appeal on 11/8/2023, inter alia has been pleased to pass the following order. What the Rajasthan High Court has stated above, it is a settled legal position. In a recent judgment of this court in state of Manipur versus B. Suraj Kumar Program and others, this position that a statute has been made by competent legislature is valid. It is declared unconstitutional by a court has been reiterated. Consequently, the appeals are dismissed and the judgment dated 25/11/2021 of the Rajasthan High Court is upheld. The notification dated 28/6/2018 is hereby quashed and set aside. The writ petitions and all pending applications stand disposed of in light of the above order. The present application for modification of the clarifications filed by applicant Mr. Arnab Ghosh. The prayer made is to modify the judgment dated 11/8/2023 passed in civil appeal by clarifying that the appointments to the post of primary school teachers shall be made as per the recruitment notifications issued prior thereto. This may kindly be marked. For the other applicants, Mr. Achanta Dhara and Ms. Tanishka Das, who intend to come on record through impeachment are persons belonging to the state of West Bengal and B.Ed degree holders are aspirants to the post of primary school teachers. They have applied pursuant to notification dated 23/12/2022 issued by West Bengal Education Board, which is subject matter of challenge before the Honorable Calcutta High Court. It is well settled that applicants cannot seek for review or recall or modification of the order passed by this Honorable Court in the guise of filing applications. Deprecating the tendencies of the litigant in prolonging and indulging in endless litigation, this Honorable Court in the matter of Indian Council for Environmental Action versus Union of India, and then I was referring all these judgments.
25 directly. 25 last part.
Is 25. It is clear that the applicants in both applications intend to seek for recall or review of the order passed by this Honorable Court in the guise of filing the present applications. The prayer made in these applications itself would make it clear that applicant intends to seek for re-hearing of the matter on merits after reviewing the order dated 11/8/2023, which is impermissible under law. This Honorable Court has been pleased to reiterate the law and confirm the judgment passed by the Honorable Rajasthan High Court, and necessary consequences would follow. This may kindly be marked.
Means appointments made 10 years ago will also.
Do not accept what I am saying. My duty.
They are wasting the valuable time of this honorable court, not saying something which is not written in the order. It means necessary consequences means appointment.
Let him complete.
The applicant intends to re-agitate the matter by filing miscellaneous application for clarification of the modification which cannot be permitted under law. The other applicants who are aspirants to the post of primary school teacher in West Bengal Education Board were not parties, and even according to their application, their challenge is pending before the Honorable Calcutta High Court. The aforesaid principles consistently laid down by the Honorable Court would reveal that no application seeking for review, recall, modification of the order of the judgment is maintainable under the same is not envisaged in law. When the said principles are applied to the present application, it is clear that applicants are attempting to re-agitate the issue and obtain indirectly, which could not be obtained directly from this Honorable Court. This is very important, my lords. There are absolutely no reasonable grounds made out to the applicants to entertain these applications. For all these reasons, I refuse to receive the present application as it does not disclose any reasonable cause for being entertained, and they were dismissed. Now, my lords, this order of lodgement was challenged at page 27. This is what on last occasion respondents referred that the matter is pending with an enough goals. I'll take your lordship to the last order sheet. Your lordship may now kindly mark this IA number. Please come to the prayer at page 28.
Yes.
Set aside the impugned order dated 22/9/2023 passed by learned registrar Judge Listing MA diary number 36321 of 2023 and directly learned registrar to register MA diary number this and this. However, this matter was referred to the bench which delivered Devesh Sharma's case at page 29. Justice Anuruddha Bose, Honorable Justice Sudhanshu Dhulia.
The date is important. 11 January.
11th January 2024. On 11th January 2024, after hearing all the parties,
Please see the prayer also, please.
it is the IA challenges to logical order. Dear Lords, after hearing them, kindly see at page 30. We are not inclined to entertain this application, the miscellaneous application. Now, my lords, at this juncture, I will wait. Please come to your lordship's order of 4/1/2024 in case Srinandan and other connected petitions. If your lordship comes to the 4 January 2024 order,
Yes.
kindly see, my lords, after hearing learned counsel for rival parties and facts which have been brought to the notice of this court, that an application for clarification bearing the MA number 2206 of the 2020 is still pending consideration before Apex Court and is tentatively listed before the bench on 11/1/2024. As per the website of the Supreme Court, it would be appropriate to await the verdict of Apex Court. Anxiety has been expressed that B.Ed. appointees who had filed MA 2206 of the 2023 before Apex Court may delay the matter by keeping the said MA pending for long. In view of above, this court deems it appropriate to observe that on the next date of hearing, if no clarification is granted by Apex Court, then this court may be free to decide the matter on merits. Interim relief may need to continue till next date of hearing, and then the matter will be listed on 20. So, this very MA, which was in lordships omitted, this was dismissed by the very same bench which delivered the judgment in the case of Devesh Kumar.
My lord, let me explain it.
All arguments not, I do not discuss it.
He has not finished.
I know what, it will help.
No, we can't have arguments piecemeal.
Now, my friend, this was done. The things now which has become very much clear is that the B.Ed candidates who were the beneficiaries of all those advertisements issued prior to 11/8/2023 approached the Honorable Court in a pretext that judgment of Devesh Sharma should be treated to be a matter of prospective overruling. All appointments made, all process initiated, they should terminate in the benefits of the B.Ed candidates being treated eligible till the notification was quashed. Now, Manas, that clarification, the lodgement order was dismissed, the application was also dismissed. Now, Manas, without wasting a lot of time, please come to the judgment of High Court of Patna, which was seized with the very similar position which your lordships are seized with. Your lordship may kindly come to the compilation page 36. And I'll take your lordships to the page 43.
Yes. Yes.
Please come to Manas the fact from page 6/12/2023 order. The writ petitions, your lordship got it?
Yes.
The writ petitions agitate the issue of consideration of candidates having B.Ed from any national council for teacher education for appointment as teachers in primary schools holding classes between 1 to 5. The stipulation to entitle B.Ed qualified candidates made applicable for teachers post in primary schools came by way of a notification issued by NCTE on 28 June 2018, which has now been set at naught by the Honorable Supreme Court in Devesh Sharma versus Union of India. The writ petitioners challenged the notification before this court by the apported petitions in the year 2021. In the meanwhile, a similar challenge raised before the Rajasthan High Court was allowed by judgment dated 25/11/2021, rendered by a division bench of that court. It was said that judgment challenging the SLP which resulted in the decision in Devesh Sharma Supra. In the above writ petitions by order number 3 dated 16/7/2021, a division bench of this court permitted the respondents to carry on with the process of selection and appointment during the pendency of the writ petition, but made it subject to the outcome of the writ petition, and also stipulated that the candidates selected and appointed shall be made aware of the pendency of the writ petition. Exactly the same situation. IA number 1 of 2021 filed on behalf of the interveners who were B.Ed qualified for implement as party respondents in the main writ application was disposed of without allowing the prayer for implement, but reserving liberty to file afresh if the need to arises. However, the applicants were permitted to assist in the matter, and it was also directed that the London Council would be sent a link of the proceedings for online hearing. A further including petitions seeking permission to be included as petitioners to support the cause of those qualified with a diploma in elementary education was rejected. But yet another division bench as per order number this and this. Now, your lordship may kindly come to para 6. A preliminary objection was raised insofar as the selection having been proceeded with and appointments having been carried out. The lordship are getting para 6.
At page 45.
Please come to para 6, the very same position. A preliminary objection was raised insofar as the selection having been proceeded with and appointments having been carried out, none of whom are before the school. However, it has to be noticed that the selection was proceeded with on the basis of the amendments made to the rules of the state in accordance with the modification brought about to the essential qualification by the NCTE in the year 2018 by virtue of interim order number 3 referred to law. The division bench had categorically observed in the said interim order that the pendency of the writ petition shall be intimated to the candidates selected and appointed, and they shall not claim any equity since that selections and appointments were directed to be carried out only subject to the outcome of the present writ petition. So, one of the very same position here, we challenge the state rules, we challenge the NCT notification, the lordship passed an interim order that the appointment shall be subject to the outcome of the writ petition, awaiting the Devesh Sharma's final verdict. The interveners who support the cause of B.Ed candidates are before us, and despite the pendency of the petitions having been communicated to the appointed candidates as vouched by the government advocate, none except the interveners herein have sought implement. Their cause being adequately educated before this court, there is no scope for any further directions to be issued for implement of the affected parties, who, despite intimation of the pendency of the petition and their appointments being subject to the final outcome, have not cared to get themselves implicated herein. We proceed with the matter, especially noticing that the issue is no longer res integra going by the decision in Devesh Sharma Supra. Sri Nignath Molly, London Senior Counsel, however, pointed out that though there is no specific.
All right, we'll continue on the next working day. What's that?
Next day will be 29th and all, we are.
Supplementary list for Delhi. Bani nahi hai.
Next week may not be taken, we will take it after that.
Sorry, Milord. Sorry.
Monday, Monday we are advertising.
There is some urgent matter which has been said. The supplementary list is coming in 2 minutes. For 2 minutes, you can continue.
On Monday, then I'm praying for on Monday the time. Because Monday is the next Monday.
Because if I adjourn your matter, then I will have no work to do for the next 2 minutes or 5 minutes. Continue for 2-3 minutes till the supplementary list comes.
Milord, we will also make our submissions that it can be distinguishable on facts in Devesh Sharma, and MP has its own rules.
Yes,
and
you will get your chance on the next working day.
Should I kindly now come to that paragraph?
You were where? Para 9?
Para 7, my lords.
7.
7:46.
Mriganth Molly, London Senior Counsel, however, pointed out that though there is no specific express intent as available in the judgment, the fact that the Honorable Supreme Court, while deciding Devesh Sharma Supra, has in the operative portion found fault with the state government for not having permitted the B.Ed candidates to participate in the selection that was notified in the state of Rajasthan. This action of the state was held to be improper since the constitutionality was not being decided at that point of time. This made the decision prospective in nature, and hence the instant selection and appointment carried out prior to the judgment would have to be upheld by this honorable court. So, Maharaj, that's the very same position that whatever has been done should be saved. Then, Maharaj, may kindly see. Further garner support for the proposition of prospective overruling, the learned senior counsel placed reliance on Soumya Organics, Kailash and Sharma, all these Maharaj. Reliance is also played on all these. Then, your Lordship may kindly turn to para 13 at page 49. There, Maharaj, the Honorable Division Bench start noticing the facts regarding coming out of this notification. We have to notice the notifications from there, Maharaj, dealing with Ramcharan Maurya, Devesh Sharma, all those judgments. Now, your Lordship may kindly come. Page 20, para 19, page 55.
Okay. 50. Right.
Page 55, my lords. Page 55.
Sorry, man, page 58.
Yeah.
Para 24. Now the question arises as to whether there is any justification for the argument that the declaration made in Devesh Sharma Supra is prospective in nature. Soumya Organics applied the doctrine of prospective overruling and referred to Golaknath when the parameters of such power were laid down at first and it was noticed that Golaknath laid down that doctrine of prospective overruling can be invoked only in matters arising under our constitution. It can only be applied by the Honorable Supreme Court, and the scope of the retroactive operation of the law declared by the Honorable Supreme Court superseding its earlier decisions left discretion to itself to be molded in accordance with the justice of the cause or the matter before it. Prospective overruling was found to be a recognition of the principle that the court moves the relief claim to meet the justice of the case. Justice not its logical but in its equitable sense. There is no such express declaration made by the Honorable Supreme Court in Devesh Sharma Supra in Lordship kindly notice. Much has been argued about the Honorable Supreme Court having noticed that Rajasthan government, when issuing an advertisement, had not included the qualification of B.Ed candidates, especially when they were made eligible as per the statutory notification of the NCTE, which was also binding on the Rajasthan government. This impliedly indicates the prospective overruling is the contention raised, which we are unable to accept. The above observation was only in the context of Rajasthan High Court, having set aside the notification dated 28/6/2018. In the operative portion of its judgment, had the state government could not have ignored the notification of the NCT while issuing the advertisement. The Rajasthan High Court had clearly stated that since the notification itself was declared illegal, the issue was only of academic value.
We'll take it up on the next.
Marks.
My lords, consider recording it as a part heard by the petitioners.
Only,
Case stands part heard. Let the case be taken up on Monday. Hearing the remaining part of the
Grateful, my lords, deeply grateful.
application state which has been filed today. Today, IA number so and so shall also be for deferring the hearing of this petition shall be taken up on the next date of it.
Instead of that, I know I'm not taking up to be next week. We're all out for
Provided the other side agrees.
Members of the bench, I think, at least for 2 days, at least for 2 days, even the members of the bench. So now marked as a part.
Now memory will fade.
After 1 week, the actual memory.
No.
only request take it up on time. They are also aware that they will login malware by that time.
3:30.
3 or 2:30.
You make your arguments concise, precise.
This segment only covers every aspect.
One intelligent person, but my letter friend will not accede to that. Making it, can I take it up? It's marked as a partner now. 5th of the
So if we are opposing any kind of further adjournment,
argument that has happened, they have to way the recap. Therefore, I'm
grateful, I was deeply grateful.
Lordships are fixing 3:30 minutes.
Never we start. My learned friend has created great confusion. I will like to respond first. Then if anything is required, then I just want to clarify that what
You are an intervener, Mr. Rupra. Interveners only have a right to audience. That is all. You are not the main.
We are respondents.
Well, so we'll hear the main contesting respondent first.
That's why I was simply suggesting in one case I will intervene.
Your lordships will hear me, my lords. My impleading has been allowed, not lordship will hear me after this.
In the case
My lords have got the gist that why is there being so much of delay that is being caused, my lords. So 29th would be a good date to hear, my lords.
my lord, over the shift. My lord, in the case of Vipin Kumar Dwivedi, please allow my ID 17229 today.
My lords, we oppose any application being allowed at this stage.
Similar applications of Mr. Kejriwal have been allowed. My application may also be allowed, lest I may again face some objection like this.
We vehemently oppose any such application.
You are for?
I am for that B.Ed. candidate who has been appointed this election in March 2023. And this person has become intervener in KC Nandan, but KC Nandan may not reach the argument stage because what objection Mr. Kejriwal has been taking. So, Lord, my humble submission is that this application of mine to be arrayed as a respondent may kindly today allowed. I'm sure my learned friend will not object to that.
We'll hear you after you can distinguish this Patna High Court's decision.
Not just Patna High Court, but the Uttarakhand High Court has also followed it. So the Uttarakhand High Court has also taken a view similar to Patna High Court.
Let them separate those judgments, not we will distinguish them. We will distinguish them.
Final argument is taking place, Lord. IA 17229.
Patna High Court judgment has been tested.
Not tested, my lords, but a similar writ petition has been filed in the Supreme Court and that writ petition has been dismissed with costs. With a similar prayer.
Any material.
My Lord, I take it up on the fifth, but please, first, clarify the confusion. Only on
Not today, not today. Not today, on the next one.
Not completed. What's the effect
Let him complete on the next.
Effect of Arnab Ghosh and effect of Guddu. My learned friend has wrongly put before this on the.
You can respond it when they ask.
You will get your chance to argue.
They are misleading people.
They are saying that we are dilating on the day.
He should have outside disclose this fact that the judgment is under challenge before the Supreme Court.
Let me make my.
Let him later.
I'm not.
Take it up on 5th, Malak.
No, not on 5th. We'll forget
Take
everything.
it up, Malak.
We'll forget everything. Forget everything.
Because the intention of the state seems to be clear in this. 29th will be good, Manoj. Grateful, Manoj, deeply grateful.
Lordship,
Take it up. My IS stands allowed to give that favor my kindly.
No, not you. It's kept pending. We'll take that up also.
No, they kind enough to allow the same application, Mr. KTR. So I'll be answering.
We'll recall that order.
my lord, we are
I'm here, Lord, I'm here already. So allow us to reply after the petitions argue.
If my laws are not agreeable for the week after that, can I not pick it up?
Can be 29th or at best 30th.
Because 29th is good, Manoj. Either way, the petitioners will have to conclude. They can argue on 30th if required.
Let it be 30th. Let it be 30th.
Take it up on
29, we will complete plus 30.
Because we need at least 20 minutes to complete, so petitioners can complete on 29th.
We'll accept your request to the extent of 30th. That is all. Not beyond that. Tell you.
Lordships are fixing a time, my lord. Lordships are fixing a time. Lordships are fixing a time, my lord.
3:30.
Very well. Very well.
Lordship, we are,
that my application will be considered on 30th.
my submission is Lordship, we are interveners and Lordship ने कहा था कि interveners को भी सुनने का मौका दिया जाएगा. Lordship, हम लोग सब appointees हैं और लगभग अब ऑर्डर 11 अगस्त 2023 के ऑर्डर से पहले हमने जो अपनी अपॉइंटमेंट्स पा चुके हैं लॉर्डशिप भी सुनने का मौका लॉर्डशिप.
आपका इंटरवेंशन का सुनेंगे नेक्स्ट सेशन.
हाईली ऑब्लाइज लॉर्डशिप.
Yes.
Deeply obliged.
3:30. Yes. Who is in this? Srimati Fatima Begum.
Bill number 39, Shri S.A. Khan